Hello, good afternoon, welcome. My name is Perla Rodriguez, and I am president of the San Jose Spotlight Board of Directors, and I am very pleased to be here with you this afternoon. Today, as you know, we're having a discussion with Santa Clara County Assessor Larry Stone, and we're going to talk about a very complex issue, which is California Proposition 19, which, as you know, was approved by voters last year and applies to intergenerational transfers of property. I want to encourage everyone to use the chat box this afternoon to enter any questions that you may have. And we hope that you'll come away with a lot of great information from today's presentation, which will also be followed by a Q&A. To start things off, I am going to go ahead and turn it over to Santa Clara County Assessor Larry Stone and members of his team. Thank you, and once again, welcome.
Well, thank you, and good afternoon. You know, to date, I have given several presentations on Proposition 19, probably about 5, and there's 3 that I think we have next week. In total, nearly 3,000 individuals so far have registered for one of these presentations. So if you attended an earlier session, I want to apologize in advance as some of the material will be repetitive. Unlike prior webinars that we gave in early February, which focused almost exclusively on the narrowing of the parent-to-child's property tax exclusion, this session will be broader. It'll be a broad overview of Proposition 19. My staff and I will also provide the most up-to-date information on the current status of legislation and insights from the State Board of Equalization. Now, assuming most people on this webinar do not have regular contact with an assessor's office, I want to provide you with some basic information about my office. Every 5 years, we're audited by the State Board of Equalization. In the last 4 BOE audits during my 26-year tenure, the accuracy of our assessments have met BOE standards 98 to 99%. During my term in office, the assessment roll has increased 379%, from $115 billion in 1995 to $515 billion in 2020. My staff has increased only 4.5% during those 26 years. Santa Clara County employment, however, has increased 64% during the same period. We have returned $21.3 million of the assessor's budget back to the general fund unspent. In other words, I have underspent my budget in 25 of the 26 years. The result of all this is nearly $6 billion in property tax revenue each year for schools and local government. Context is important for understanding Proposition 19. Assessed values have become valuable unto themselves. With the passage of Proposition 13 in 1978, assessed values are no longer market-driven. Instead, assessments are based upon the purchase price at the change of ownership or new construction, and then increase no more than 2% a year. As a result, assessed values over time are far less than market values. One's low assessed value has become a prized asset, cherished by longtime homeowners and envied or even despised by younger first-time homeowner wannabes. Over time, California voters have approved several ballot initiatives intended to retain low assessments, even passing assessed values onto their children, and in some cases, even to their grandchildren. Proposition 19 is the latest effort in that regard, but it, unlike its predecessors, was terribly written. Attendance today on this webinar is overwhelming, with over 300 attendees signed up. And while I'm pleased my office is sponsoring this event today, candidly, I wish it was never necessary. For more than two decades, I've administered the property tax system based upon a simple premise that there were always clear rules of the road. Proposition 19 contains major changes to the state constitution, overhauling or even eliminating 5 previous initiatives. Most of the provisions are confusing, ambiguous, and conflict with the initial intent of the ballot measure. To make matters worse, the legislature has been unwilling to pass comprehensive implementing statutes. Instead, the legislature has offered just a handful of fixes, which are still awaiting passage. To understand where we are today, it's important to understand how we got here. For decades, with little success, there have been attempts to expand Proposition 60, the initiative passed in 1986, which enables homeowners over the very old age of 55 to transfer their coveted assessed value to another home of equal or lesser value without reassessment to market value. Proposition 60, principally designed for empty nesters wishing to downsize, is relatively straightforward. 2 years later, the voters passed Proposition 90, expanding the benefit to other counties. However, the intercounty transfer allowed each county to choose whether to participate. Well, not surprising, only 10 counties out of 58 agreed to participate in Prop 90 transfers. The reason? The loss of property tax revenue, of course. Why did Santa Clara County opt in to accept Proposition 90 transfers? Well, raw political pressure on the Board of Supervisors is the answer. In 2008, Florida voters passed Amendment 1, known as Save Our Homes, championed by Florida State House Speaker at the time, Marco Rubio, which allowed homeowners, just like Proposition 19, to retain low property taxes when they move to a new home. Proposition 19 was initiated by the California Realtors Association for the same reason, that it would create more transactions and therefore more real estate commissions. Encouraged by the success in Florida, the Realtors Association began pushing for a universal Prop 90, allowing transfers to all 58 counties. The Realtors' proposal, however, was a non-starter for parents and others concerned about the huge loss in revenue, estimated by the Legislative Analyst's Office to be $1 billion a year, negatively impacted funding for schools and local government. Well, undeterred, California Realtors mounted a campaign to collect signatures to qualify Proposition 5 for the November 2018 ballot. Proposition 5 also allowed homeowners over the age of 55 to purchase a larger, more expensive home in any of the 58 California counties and retain most of the property tax benefits, defeating the original intent to assist empty nesters, seniors who wanted to downsize from a large home, or to enable grandma to get closer to the grandkids. Proposition 5 failed by a margin of 60 to 40 because Californians are not Floridians. Cutting funding for public education was a bigger concern than the additional tax cut for longtime property owners like me, already benefiting from Proposition 13. In addition, firefighters and teachers unions threatened to fund a campaign to defeat Proposition 5. Realtors argue today, seniors living in high-valued homes with low assessments are trapped in their homes, and Proposition 19 frees them from this financial burden. Well, actually, first-time home buyers are the ones trapped out of home ownership. Firefighters and teachers unions told the realtors that unless they found revenue to offset the loss, they would once again fund a campaign to defeat the new proposition, just as they had successfully defeated Proposition 5. So California realtors had to find a major source of new revenue to pay for the huge loss in revenue created by a universal Prop 90, available in all 58 counties. They decided on eliminating a tax loophole, the exclusion from reassessment of parent-to-child transfers. In 2017, California's Independent Legislative Analyst's Office issued a scathing report on the inheritance exclusion, that's Proposition 58, whereby children are able to inherit their parents' principal residence and retain their low assessed value. The LAO estimated that 60 to 80,000 property owners have received this benefit at a cost of as much as $1.5 billion in lost property tax revenue annually. In addition to the transfers to the principal residence, Proposition 58 also allowed transfers of additional property assessed at $1 million. The LA Times did a serious investigation revealing the unfairness of this loophole. The Times reported that celebrities like Beau and Jeff Bridges had inherited a 4-bedroom Malibu home from their actor father, Lloyd Bridges, with access to a semi-private beach and panoramic views of the Pacific Ocean. The investigation revealed that the Bridges rented the home for $16,000 a month and paid approximately $5,000 a year in property taxes. Frankly, California realtors did not care much about this part of the Proposition 19. They just needed to find a $1 billion to offset the $1 billion lost from a universal Prop 90. Almost immediately, assessors and other powerful interests like the California Farm Bureau identified major problems with the language of Proposition 19. Farmers who historically passed the family farm from generation to generation recognized that they would be the big losers. And ironically, they may still be. With major political problems building and the likelihood of organized, well-funded opposition from farmers and labor unions, the realtors asked the legislature to step in and fix the problem. As a sweetener to moderate Democrats hesitant to support a tax increase, they promised the revenue would be allocated with a very special and very convoluted formula that would likely benefit rural counties over urban counties. In just 6 days, a half-baked Proposition 19 passed the legislature, mostly behind closed doors. It was so late in securing legislative approval that the governor had to step in and sign special legislation tolling the required deadline in which an initiative must be approved by the legislature. The result is the mess we are now dealing with, Proposition 19. Regardless of what you think about Proposition 19, which I actually voted for, it is the law of the land. As your assessor, I'm committed to making sure it is well understood and the taxpayers receiving the maximum benefit allowed. It is why California assessors and the State Board of Equalization have been scrambling to try to interpret Proposition 19 and determine how it will be implemented. More than anything, assessors want to ensure uniformity and fairly implement all tax laws. Equal application is not just a goal for assessors, it's a fundamental axiom. A property should receive the same treatment no matter where it is located. Subject matter experts in assessors' offices from Los Angeles to San Bernardino, San Luis Obispo, Kings, and Santa Clara County, together with the State Board of Equalization, have been meeting weekly, often daily, to clarify and identify problems that must be addressed by the legislature and the State Board of Equalization. Unfortunately, the legislature, limited by COVID-19, determined that they could not consider such a major piece of legislation and pass it by the February 15th deadline for the implementation of the parent-to-child transfers. After enormous political arm twisting, assessors and the State Board of Equalization were successful in persuading the legislature to introduce SB 539, nicknamed the Skinny Bill, which was largely drafted by assessors and State Board of Equalization staff. It provides the absolute minimum legal backstop that assessors require to administer the parent-to-child provisions of Proposition 19. There's almost nothing in SB 539 concerning other portions of Proposition 19. Now, it's not ideal, but if passed, it will provide some of the desired legal authority for assessors and the BOE to act uniformly. Effective April 1st, 2021, the other sections of Proposition 19 become operable. These permit eligible homeowners defined as over the age of 55, severely disabled, or homes destroyed by wildfire or disasters to transfer their primary home's assessment to a replacement residence of any value anywhere in the state. The math is relatively straightforward. Essentially, if your new home is purchased for the same amount or less than your prior home, your low assessed value will not change. If the market value of your new home is more than the sales price of your old home, the difference is added to the assessed value of your old home. Let me give you an example with my home. In 1975, I purchased my current home in Sunnyvale, a 3,000 square foot modest tract home on a 10,000 square foot lot for $85,000. It is currently assessed at $276,000. Zillow says that the market value of my home is $3.1 million. As long as a new home has a market value of $3.1 million or less, my $276,000 existing assessment transfers to my new home. However, if I buy a new home for, say, $4 million, then my assessed value jumps from $276,000 to $1,276,000. Keep in mind, assessors look only to the marketplace to determine the market value of both homes. It's standard assessment appraisal practice. To simplify the process, we have created a new electronic calculator to help homeowners estimate their new assessment. In addition, and pending clarity from the legislature and the State Board of Equalization, Proposition 19 allows eligible homeowners to keep their low property assessment when moving to another home anywhere in the state. Use special rules to move to a more expensive home. Their property tax bill would increase, but not near as much as it would for non-Prop 19 transfers. Use these special rules a maximum of 3 times in their lifetime. Proposition 60 and Proposition 90 sunset on March 31st of this year. To receive the expanded portability of Proposition 19, homeowners must complete at least one of the transactions on or after April 1st. Let me repeat, you do not need to wait until April 1st to be eligible for these provisions of Proposition 19. At the insistence of assessors and the State Board of Equalization, SB 539 makes explicit that only one transaction must occur after April 1st. Property owners have 2 years from the transfer of the first property to complete the second transaction. Proposition 19 also supplements existing transfer provisions for victims of wildfires or disasters or owners who are severely disabled. Upon implementation, taxpayers will have to determine and apply for those provisions which are most advantageous for their particular circumstance. Effective February 16th, 2021, Proposition 19 substantially narrowed the property tax benefits for inherited properties. Specifically, the measure restricted the assessed value that can be transferred to 2 kinds of inherited property. Property used continuously, underscore continuously, by the child or grandchild as the primary home, or property held as a family farm. The measure has a convoluted formula to qualify and to complete the benefit. Basically, the assessed value of an inherited home or farm would increase if the market value exceeds the property's base value by more than $1 million, adjusted for inflation every 2 years. Nora Galvez, one of the leading experts in California on the transfer of ownerships, will go into greater detail about the mechanics of the formula. To make things easier, our office has developed an electronic calculator that will enable residents to calculate the savings. The biggest change was the elimination of Proposition 58 and Proposition 193 from the state constitution, which provided generous property tax benefits to inheritors of homes and commercial properties. That is gone as of February 16th of this year. Nora and my Deputy Assessor David Ginsborg will explain what we know and how we plan to administer Proposition 19. My office has created a robust website that includes legal opinions, new forms, and other information that will help all of you make informed decisions. So in closing, it is our intention to provide a general summary of Proposition 19. It is not intended to be an absolute legal interpretation. Proposition 19 is a constitutional amendment, so additional legislation, regulations, and state guidance is necessary to clarify its implementation. If there's a conflict between the information provided here and the proposition or any legal authority implementing or interpreting the proposition, the text of Proposition 19 will prevail. And finally, I want to remind everyone that we will do our best to provide general guidance. However, our office does not provide legal advice to specific situations. And now I'd like to turn it over to my Deputy Assessor, David Ginsburg, to talk about the current status of legislation, rules, and guidance on Proposition 19. In addition, he will go into detail about the base year transfer components of Proposition 19. He will be followed by Nora Galvez, who will go into detail about the parent-to-child portions of Proposition 19. Also today, we have Debbie Chavez, one of my appraisers, who helps administer Proposition 60 and 90, and will be assisting with Proposition 19 implementation. And lastly, we have someone from the County Recorder's Office to help answer any question that you may have. So now I'll turn it over to David.
Thank you, Larry. I am now just about to put on the screen here my PowerPoint presentation. I have to switch. Give me one moment, please, everybody.
Okay.
All right. Hopefully by now everybody's starting to see my screen here. Okay. Good afternoon, everyone. I am going to first start off with some legalese. I'm not going to read this to you. Everyone can read this, and this will be, all of our presentations will be available at a later time. But in a nutshell, we are doing our absolute best to implement the law in a manner that is consistent with the Constitution and what we believe is intended by the voters, as well as the plain language of the law, to the extent that it is clear. So unfortunately, Proposition 19 is not anything but clear. It's the Board of Equalization in a memo recently noted, it said, unfortunately, the text of Prop 19 left a number of significant questions unanswered that are critical to its proper implementation and administration. And just to give you sort of a flavor of this, I've highlighted in here, it says, that they had provided advice to assessors in November, and by January, they had recognized that the advice they had provided was insufficient and had to be superseded. So it's an ongoing process of trying to understand. And people ask, well, what happens? Well, who has final say? Well, the way it works is we start with the Constitution, and then it is the state legislature is supposed to fill in the gaps. And they're supposed to provide implementing statutes. And then where there are still more gaps, the Board of Equalization provides rules. And this is important because these apply statewide. And then finally, the court steps in. Well, in the absence of implementing statutes, Board of Equalization rules, and court decisions, it relies upon the state's 58 constitutional officers, the assessors, to interpret Proposition 58. And fortunately for us, we have the assessors are an extraordinarily professional organization. They all 58 are members. These are people who are primarily subject matter experts. They're professional administrators. They're typically not politicians. Their job is to try to administer the law. They're not policymakers. And they immediately after the election formed an ad hoc committee that identified the best experts in the state, and they of course turned to our county, one of six counties involved with this. We then broadened that committee process to work with the staff of the Board of Equalization and their experts. And our very first step was, okay, where's the differences between what's in the Constitution and what we need in terms of law so that we can implement this? And we arrived at a 45-page document that outlines all the variations from what we need for implementing this law. And we work very closely with the legislator, and they initially indicated that they would be receptive to legislation to help us implement this. We drafted legislation over the holidays, 30 pages. And when they got it, they realized it was going to be too much for them, even though this was a mostly administration, things around filing forms and deadlines and things like that. So we, in the absence of that legislation, we went back to them and said, look, you've got two different parts of this initiative. One that gets started on February 15th and the other on April 1. Let's get some urgency language having to do with the first portion of this initiative. And they looked at that, and that's what Larry referred to as the skinny bill. It's SB 539. But actually, let me just restate before we get to the 539, there is one other piece of legislation that was introduced. It's called SB 668. And that legislation basically says, ignore what the voters are demanding and just set aside the whole law for 2 years. Well, obviously, the state legislature cannot overturn what the voters have directed. So it's unlikely that that legislation ever goes anywhere at all at this point. So back to SB 539, the goal was to get this passed by February 15th. Well, it didn't get introduced until February 18th, and that was only at the urging of assessors. It focuses almost exclusively on the intergenerational portion of the law. And it goes into several aspects of the intergenerational portion of it. And on the screen, it goes through, talks about the family home, the family farm, filing requirements, and it gives the Board of Equalization clear rulemaking authority, which is going to be very, very important. That has now passed 2 committees in the state legislature. It's on a fast track. It has passed unanimously in those committees. And so we are working very hard, the assessors together, to try to get this passed by the end of March, beginning of April. That's our target date for this. But as I noted, this only covers a small portion of the intergenerational portion of Proposition 19. So what do we do? Well, we're working with the Board of Equalization on rules. Rules are binding. Those are things that where if the assessor doesn't do it in a manner consistent with the rule, then the assessor can be overruled by the courts and such. And so we are working with the Board of Equalization on drafting rules. They have issued a detailed 11-page set of rules for this measure that was has just been circulated on March 4th, and it's going to go through its process. I wish I could say it's a fast process. It is anything but fast. It will require 12 to 15 months from start to finish to get a rule adopted. There'll be hearings along the way. Now, in addition to this, the Board of Equalization is providing what I call a lot of non-binding assistance. These are things such as the forms, the guidelines, legal opinions. And again, the goal is for all 58 assessors to look at and to do things consistent with each other. So if you look at what's in SB 539 having to do with the base year transfer portion, which is where I'm going to now focus the remainder of my presentation, there's not much in this bill, very, very little. Thankfully, one of the things that has been put in here is to make absolutely clear and to put into law this idea that you only have to have one transaction after April 1. That's an important issue for everyone. But there's a lot of things that are not in this bill as well. It is woefully inadequate for any number of issues. We are, things having to do with the natural disasters, things having to do with, it doesn't formally sunset all the laws having to do with Proposition 60 and 90, which do expire on March 31. So what we are doing in the interim, because we're working to get an additional piece of legislation having to do with the base year transfer. In the interim, we're also going to be working with the board to create rules around this portion of the law. The Board of Equalization has created forms, which are now on our website. So we have 7 new forms that were created. We are working with the BOE on creating additional guidance. Those like what they have already created on the intergenerational. We expect there to be many pages and many Q&As, legal advice, and things along those lines to help assessors throughout the state uniformly apply this. The essential requirements. Larry went over these. I don't know that I need to go back over all of them, but again, Prop 6090 expires on March 31, and the main thing is you only need one transaction after April 1. Okay. So I want to explain a little bit about the transfer process, just to make it very clear. I've got two nice examples here. We have one property with a taxable value of $300,000. That's what we call as the assessed value, and they sell it for $900,000. They buy a new home for $700,000. They immediately are able to take the old assessed value, the old taxable value becomes the new taxable value. It's still $300,000. In the second example, same home, same taxable value, same sales, same sales price of $900,000. They buy a new home. The new home is $1.4 million. Well, the difference between $900,000 and $1.4 million is $500,000. You add that to the 300, and that's how you get it your new assessed value of $800,000. There's oftentimes questions about how does the assessor determine market value, and this is important for both parts of Proposition 19. We have to look at the fair market value, and that is how assessors do their job. We look very carefully to the sales and purchase prices, and we accept those. But again, they must reflect current fair market value. And if for some reason the price does not reflect that, and the appraiser determines a different value for the fair market value, we use the fair market value that the appraiser determines. Of course, all of this is subject to, an independent appeals board that somebody can say if they don't agree with the assessor, they can always go to an appeals board and have it adjudicated and get resolution based upon the independent appeals board. And now the other portion of the base year transfer has to do with the victims. For people who are dealing with a wildfire or natural disaster. This is everybody says this is going to become an increasingly big deal. What's interesting about this is that the existing laws having to do with the ability to transfer your base year value if you've been affected by a disaster, government declared disaster, does not sunset. This new law, as we believe, will be in addition to the existing laws. And there are, in some aspects, this new Prop 19 portion of the law having to do with natural disaster provides some additional benefits. And in some aspects, it provides less benefits. So it's a mixture. And as Larry said, you'll have to evaluate, determine what's best for you in terms of that. Now I want to go through some common questions. We received quite a few questions in advance, and we tried to what we tried to do was go through these and determine what were some of the most common types of questions, and put them into a handful here that we've collected. So the first one has to do with delaying implementation of Proposition 19. A lot of people were frustrated with it, feel like it wasn't what was promised, and they've asked us, assessors, can you delay this? Can you not implement it? And the answer is, of course, no. The voters passed the state constitution. There's been no legal challenge to it. We don't have the authority to set aside those portions for which assessors disagree. So next question, people have asked, again, this is around the transaction dates. If I've already sold my original property and will purchase my replacement property after April 1, can I qualify under the Prop 19 rules? And yeah, the answer is yes, you may. As long as it's the purchase or completion of new construction of the replacement property occurs after April 1. Another question people have been asking is, okay, I've been denied a base year transfer because my purchase was greater than the sale of my original property. In other words, you both bought and sold before April 1. And now the question is coming up is, hey, can I still do Prop 19? And the answer is you you cannot do that, I guess, unless you were to buy a third home, and it's all within the 2-year time frame. So another question was, I'm confused about the time limits. And in one instance, there's a 2-year time limit, and then there's another place where it says it's 3 years. People have had a lot of confusion around this. Let me see if I can help answer this. These time limits are dealing with 2 different issues. The replacement residence must be purchased or newly constructed within 2 years, before or after the sale of the original residence. So that's the first part, 2 years. Now here comes the second part, about 3 years. The Proposition 19 application must be filed within 3 years of the date of the replacement residence is purchased or newly constructed in order to receive full benefits. If the application is filed after 3 years, you'll get prospective relief. Another question, if I've sold my home and bought my new home in Santa Clara County in June of 2021, and it takes 6 to 18 months to process, how much taxes do I pay in the interim? Well, the answer will be based on the purchase price until the application is approved. Once the application is approved, you'll be getting a refund from the tax collector for any overpayments. Typical turnaround time is 3 to 4 months. We're dealing with right now a situation where 48 counties have never processed a base year transfer outside of their county. We're anticipate a large volume of these transfers just because there will be a lot of people taking advantage of this new law and using it. We're going to ask for everybody's patience as we work to adopt the rules, because in order for us to do our part, if you move into our county, we have to get information from another county. And we're working very closely to set up processes to make that as smooth as possible. But it is going to be, we ask for people's indulgence and patience as we make this transition. Next question, is it okay to put another person on title, such as son, daughter, brother, along with the person who's the claimant for the Proposition 19? And the answer is yes. The claimant needs to be on title in some percentage on both the original and replacement residents. It can have others on title as well. If the qualifying homeowner has a minority interest in the property, can they transfer 100% of the benefit? Again, yes, they'll receive 100% of the benefit. It doesn't matter what percentage you own. You only have to be on title of the property that's sold and the property that's purchased. Another question we've had is, individuals never applied for homeowner's exemption, but they've lived in their home for many years before they sold it. Can they still qualify? And the answer is yes, as long as they can prove that the sold property was owned and occupied as the principal place of residence, and thus meeting the residency requirement. How long do I have to live in a house before it's considered a principal residence? There is not a clear time requirement. However, the claimant in this case you have to be eligible. Again, this idea of eligible for homeowner's exemption and have lived there long enough to be able to provide the documentation. Basically, the idea is, has this truly been your home where you're living and not a rental property, for example? Next question. I am purchasing a new residence and plan to rent it out for a year or remodel it before I move into when I sell my original house. Will I still qualify? The answer is yes, if the replacement property is the primary residence at the time you apply for Proposition 19. Sort of follow-up on that is, what if I rent out my original house for a year, sell it, and then buy a replacement residence? Again, yes, if the original property is sold within 2 years. Key is that 2 years of purchasing a replacement property and the original property was eligible for the homeowner's exemption, either at the time of sale or within 2 years of the purchase of new construction or replacement dwelling. Question about application process. People have asked us, they think that the realtor or the title company is taking care of the filing. It's possible that they did, but there's not an automatic grant. And it's very important. You must fill out the application. And if you're not sure you filed the application, call our office to confirm. You don't want to find out the hard way. Next question is, you've transferred your home under Prop 60. People will have asked, can I transfer again under Prop 19? And if so, do I get 2 times or 3 times? And the answer is, the clock starts over. You get up to 3 times under Prop 19. Everything that happened before Prop 19 became law is in the past and not taken into account. Another question. I sold my house a year ago, moved out of state, and now I want to move back. Can I still qualify for Prop 19? And the answer is again, yes, assuming all the qualifications are met within the two transactions of selling the original residence and buying the new residence are again within 2 years of each other. Next question. I inherited a residence from my mom this year and I filed for and received the parent-child exclusion. Can I, many years later, when I turn age 55, sell this property and transfer my mother's base to another property that I purchased? Yes, the answer is as long as you've moved in the inherited residence and live in it as your primary place of residence. I mean, technically at that point, it's no longer your mother's base, it's yours. Next question. I purchased a replacement dwelling in March of 20. My original property later sold in November of 21, and I filed a claim to transfer the base year value. Is the date of transfer the date I purchased the replacement dwelling? And in this case, the base value would be transferred as of November 21, because that is the latest qualifying date. So assuming you meet all the qualifications for Prop 19 base year value transfer, the base year value is transferred as of the latest qualifying date. And here are the different possibilities listed here. Next question. I bought a vacant lot 10 years ago and I plan to my present home and build a new one on the vacant lot that I already own. Would I qualify for Proposition 19? The answer is yes, if the date of the completion of the new construction is within 2 years of the sale of the original house. The assessor's office will do a market appraisal as of the date of completion of the new construction, including the land of what the new house would sell for. The market value of both the land and improvement is what the appraiser uses to compare with the sale of the original house. Other questions have been around severely disabled. Like the existing disability requirements, the applicant's physician must complete a certificate of disability indicating that their severe disability requires them to move into a new residence that meets the needs of their disability. Our office will provide you with a certificate along with the application for the Prop 19 or Prop 110 transfer. The most common request for transfer for disability is moving from a two-story home to a single-story home. And you'll note that unlike the existing law, which stays into place, the existing law says severely disabled and severely and permanently disabled. Prop 19 is only severely disabled, no permanently. So there is a nuanced difference there. And again, you have to evaluate what works best for you. Next question, can I transfer my tax-based value to a manufactured home? Yes, there are some exceptions, but generally you can. How long does it take to process the application? So even if all things we were experienced in doing this, if we receive a transaction after January 1, we don't begin processing those until July. That's because we are busy processing all the stuff from prior year between January and June, so we can send out your notice and tell you what your assessed value is for what happened as of January 1. We then begin working the next roll, what we call the next roll, which is after July 1, and then we begin taking on a flow basis applications we have received. Of course, we will be impacted by when we receive information from the other county. Next question is, would I still qualify for Prop 19 benefits a few months shy of 55? No, you have to be at least 55 when your original property sells. While you may be 54 when you purchase your replacement property, you must be 55 when you sell your original property, because that's when the assessed value transfers. Next question. My spouse and I just got a divorce. We're going to sell the house that we bought together, and I plan to buy a new house. Can I transfer the tax base, or am I only able to transfer half of it? The tax base is not split. Only one of you can transfer the entire base. If you qualify to transfer the tax base at this time, your former spouse can apply for the benefit in the future, assuming they have then bought another home and then wish to sell that and transfer that. Do we anticipate charging a fee to process base year transfers, just like we currently charge for Prop 90? Yes, we anticipate charging the same filing fee of $100 for recovery. It's a cost recovery only. And with that, I'm going to turn it over now to Nora, who is the chief of our standard services and exemptions and is our subject matter expert in this area. Thank you very much. I'm going to go to mute.
Good afternoon, everyone. Let me see if I can share my screen here. Let's see.
Thank you so much. In the meantime, I will remind everyone that you're welcome to submit questions through our chat box. We are following comments and questions there, and we welcome your input. Thank you.
And if I can have the ability to share my screen, that will be great, please.
Yes, hi, David. If you can make Nora the host, that'd be helpful.
Bear with us, please, as we transition. And again, once again, we want to thank everyone for participating this afternoon. We have over 141 participants joining us. And boy, there's been a lot of great information shared so far during this presentation.
David, would you be able to make me the host, please? No.
Thank you for your patience as we work on transitioning from one presenter to the other. We will complete this task in just a moment. Thank you for your patience. We're almost there. For those of you who are joining us in progress, this afternoon, we are joined by our assessor, Larry Stone, for a very informative presentation on Proposition 19. This afternoon, he's also joined by members of his team, Deputy Assessor David Ginsburg, who just provided a very informative presentation. And now we will be hearing from their Chief of Standards Services and Exemptions, Nora Galvez. She also has a detailed presentation. And if you can bear with us, we're almost there. How are we doing, Nora?
Yeah, sorry to interject. So it looks like Assessor Stone now is the host. So Assessor Stone, if you have access to a computer, you actually need to hover over Nora's name and then they give you the option make host. You'd click more. David, I don't know if you can answer the question who's, okay, she's good. We're good.
Thank you. Thank you for your patience. We're almost there. There we go.
There you go.
Hey, thank you.
Can everybody see my presentation? Can everybody see it?
Yes, we can. Thank
Yes.
you.
Okay.
We
Perfect.
started.
Perfect.
Yes, thank you so much.
Perfect. Thank you so much. So sorry, and thank you so much for your patience. So yes, I'm going to be talking to you about the provisions under Proposition 50A, which is the parent to child exclusion, also the grandparent to grandchild, and then we're going to go into the new provisions on Proposition 19, what changed, and then I have a really good example on that value test that came from Proposition 19. So let's begin with the parent and child exclusion, the parent to child exclusion. So Proposition 58 was effective on November 6, 1986, and is a constitutional amendment approved by the Borders of California, which excludes from reassessment transfers of real property between parents and children. Proposition 58 is codified by Section 63.1 of the Revenue and Taxation Code. Proposition 58 includes transfers of principal residence between parents and children without any reassessment, regardless of the value. There's no restrictions on use of the property after the transfer. So the child can inherit or purchase the property, and the child can live in the property, or the child can rent the property. There's no restrictions on that. The parent-to-child exclusion also comes with transfers up to $1 million in assessed value on properties that are other than the principal residence of the transferor. So if the parent has 5 homes, the parent lives in one, then we're going to apply the $1 million value, assessed value on the other 4 homes. The grandparent to grandchild is very similar to the parent to child exclusion. Proposition 193 was effected on March 27, 1996, and is also a constitutional amendment approved by the voters of California, in which excludes from reassessment transfers of real property from grandparents to grandchildren, providing that all of the parents of the grandchildren who qualify as children of the grandparents are deceased as of the date of the transfer. Proposition 193 is also codified by section 63.1 of the Revenue and Taxation Code. This exclusion includes transfers of principal residence between grandparents and grandchildren only without reassessment, regardless of the value. There's also no restrictions on use of the property after the transfer. And with this exclusion, like I mentioned, all of the parents of the grandchildren must be deceased as of the date of the transfer. For these two exclusions, a claim form must be filed with the assessor's office. So now the big question is, well, what is Proposition 19 and what are some changes to the current law under the because of the Proposition 19? Well, as you are aware, on November 3rd, 2020, California voters approved Proposition 19. Proposition 19 adds section 2.1, 2.2, and 2.3 to Article 13.8 of the California Constitution. Proposition 19 changes the provisions on the parent to child and grandparent to grandchild exclusions effective February 16, 2021. And it also adds new provisions for base year values effective April 1st, 2021. So what are the changes under Prop 19 effective February 16, 2021? Again, it limits exclusions to family farms or family homes only. The family home is defined as the principal residence of both the transferor and the transferee. And this is very important to make a note of. The home needs to be the principal residence of both the transferor and the transferee. And it also adds a value test for family homes, which equals to the factor base year value, which is the assessed value, plus $1 million. So let's just look at just the comparison, the difference between Proposition 58-193 and Proposition 19 provisions. So Proposition 58, as I said, transfers includes transfers of principal residence between parents to children with a reassessment regardless of the value. However, Proposition 19, there is a value limit of current taxable value plus the $1 million. Under Proposition 58-193, there's no restrictions on use of the property after the transfer. Under Proposition 19, the transferee must use the property as the principal residence after the transfer. Proposition 58-193 transfers up to $1 million in assessed value on properties other than the principal residence without reassessment. Under Proposition 19, only the principal residence is eligible. So this completely eliminates exclusions for other real property. So no more income property or even commercial property is allowed under Proposition 19. So now let's look at the value test. So these value tests actually came from that section 2.1 that was added to Article 13.8 of California Constitution. So this value test has 4 steps, okay? The first step is calculate the sum of the factor base year value, which is the assessed value, plus $1 million. The second step is to determine whether the assessed value exceeds the sum of the factor base year value plus 1 million. Number 3, we're going to calculate the difference. And then number 4, we're going to add that difference to the factor base year value. So how does this look like? So let's just look at this example. Let's just say that we have a single family residence that has a factor-based year value of $425,738. The parent dies on March 1st, 2021, and the property is inherited by the parent's only child. The property was the principal residence of both the parent and the child. On the parent's date of death, the property has a fair market value of $1,750,000. So let's apply these 4 steps. So number 1, we're going to calculate the sum of the factor-based year value plus the $1 million. So as you can see, that equals to $1,425,738. Step number 2, we're going to determine whether the assessed value exceeds the sum of the factor-based year value plus the $1 million. As you can see, the market value is greater, right, than the factor-based year value plus the $1 million. So we're going to look at the difference. The difference is $324,262. So step number 4 calls us to add the difference to the factor-based year value. So you remember, the factor-based year value was $425,738 plus the difference, $324,262, which equals to $750,000, which that will be the new combined base year value. So that's how we're going to be calculating and see whether a taxpayer is going to be able to qualify to what value are they going to be able to keep. Okay. Let's filing requirements. So the transferee must claim the homeowners or disabled veterans exemption at the time of the purchase or transfer of the family home. Remember, the home has to be the transferee's principal residence. So they need to file for the homeowners or the disabled veterans exemption. If not filed at the time of the purchase or transfer, the transferee has 1 year from the date of purchase or transfer to file the claim for the homeowners or the disabled veterans exemption. So they only have 1 year after the purchase of the transfer. So I have just a few questions that we get almost daily, to be honest with you, in regards this type of transfers in regards to changes in ownership and the parent and the grandparent to grandchild transfer. So I have a question for you. Is Proposition 19 retroactive, and would it cause property transfer that had already received the benefit of Proposition 58 to be reassessed? And the answer is no. Proposition 19 is clear that Proposition 58 applies to those transfers that occur on or before February 15, 2021. And Proposition 19 applies to those transfers that occur on or after February 16, 2021. Okay. If a parent dies prior to the February 16, 2021 date, and the assessor does not become aware of the death until a year later and reassesses the property as the date of the death, are the parent-child exclusion provisions applied under Proposition 58 or under Proposition 19? Well, the date of death is the date of the change in the ownership. There's a property tax rule that talks about that the date of death is the date of the change in ownership. So the law in effect as of the date of the death will apply. Proposition 19 is clear that Proposition 58 applies to those transfers, again, that occur on or before February 15, 2021. And Proposition 19, those transfers that applied on or after February 16, 2021. So I have a deed signed and notarized, and I have submitted it to the recorder's office prior to the February 15, 2021 deadline. What if my deed does not record by the February 15, 2021 deadline? Must my deed be recorded prior to the date in order to still be under Proposition 58 and 193 provisions? We get this question a lot. So the answer is no. As long as the date of transfer is on or before February 15, 2021, the transfer will qualify under Proposition 50A or Proposition 193 provisions. We do have a property tax rule, which is 462.260, that makes it very clear that the recordation date of the deed is reputable presumed to be the transfer day. This means that if evidence is provided to the assessor's office that the transfer actually occurred prior to the recordation of the date, then we are going to be accepting an earlier date. So such evidence could be, for example, the notary document of the date that the notary was done. That day, we're going to be taking that date instead of the recording date. Question number 6, and we do get a lot of questions in regards to trust. So how is a property held in a trust affect my Proposition 19? Well, just like any trust, there's many different kinds of trust: revocable trust, irrevocable trust. So there's many different trusts. But the administration of a trust is governed by the trust instrument itself. So we have to look at the trust to see who has the benefit of that trust, the present benefit of the trust. So for properties held in trust, Revenue Taxation Code Section 61H provides that a change in ownership occurs when any interest in real property vests in persons other than the trustor or the trustor's spouse or registered domestic partner, when a revocable trust becomes irrevocable. And usually when a trust becomes irrevocable is upon the death of the trustor. Thus, the date of death is considered to be the date of the change in the ownership. Proposition 19, again, is very clear that Proposition 58 applies to transfers that occur on or before February 15, 2021, and Proposition 19 to those transfers on or after February 16, 2021. And I just wanted to let you know, I know it was mentioned before, you can visit our website. We have great resources in there. We have great information in regards Proposition 19. And I also wanted to let you know that there's good information on the State Board of Equalization. They issued 2 letters to the assessors, and I put the numbers here. One is 2020-061, and the other one was issued this year in 2021, which is 2021-008. That is the number of the letter to the assessor if you're interested to read more in regards to Proposition 19. Also, the Board of Equalization, the Property Tax Department, the County Assessed Properties Division can answer any questions when it comes to the understanding of Proposition 19. And that's all I have for my presentation. And I believe now we're going to go over some Q&A questions. So let me stop sharing here. Thank you so much.
Thank you so much. We greatly appreciate. Very informative. For those of us, for those of you who have joined us in progress, I want to once again reintroduce our panelists. This afternoon, we're joined by Santa Clara County Assessor Larry Stone. Just to give you a little brief bio, he was first elected to Santa Clara County as assessor in 1994 and has been overwhelmingly reelected 6 times by the residents of Santa Clara County. He is the past president of the California Assessors Association, and he's also one of 5 assessors to the CAA ad hoc committee responsible for uniform implementation of Proposition 19, as was mentioned earlier in the presentation. Assessor Stone has overseen remarkable improvements to streamline office operations, eliminate backlogs, and achieve higher levels of public service, all while consistently operating substantially under budget. And the State Board of Equalization has acknowledged his office as one of the best managed assessors operations in California. Lastly, I'll mention that he has been a financial manager on Wall Street and was also the co-founder of a successful Bay Area real estate investment and development firm. And he has served 16 years as a council member and mayor of Sunnyvale. So once again, we're very thankful to the assessor for being with us this afternoon with members of his team, as you've heard already from Ms. Nora Galvez, Chief of Standard Services and Exemptions, and as well as the Deputy Assessor, David Ginsburg. So again, once again, I want to thank our presenters. We do have some questions that have been submitted in advance of this presentation, and we want to hit on a few. It's approximately 5:05. We still have a little bit of time left in this program to answer some of these questions. One of the questions that we have is, do you believe Proposition 19 will create significant stimulus for additional real estate transactions in California? And do you believe that certain counties within California will suffer as a result of accepting a lower tax basis?
Well, yes, yes, maybe, and yes, I guess is the answer to that question. The whole idea, the whole purpose of Proposition 19 was to create additional real estate transactions. That was the original reason that the whole idea was created. So whether it will, how it will affect counties is completely different. Very few people use a Prop 90 transfer, for example, into Santa Clara County because the home prices are so great. So people transfer out of Santa Clara County and out of high cost counties into smaller counties. So let me get back to my original home. If I sold my home today for what Zillow says it's worth, 3.1 million, and I moved to El Dorado County, I could buy a home, a mansion in El Dorado County for 3.1 million and carry my $276,000 existing assessment into El Dorado County. Well, that's obviously a huge loss for El Dorado County. It's a big gain for Santa Clara County because my $276,000 assessment would be 3.1 million if the buyer of my home bought it for what Zillow says it's worth. So it affects different counties in different ways. That's exactly why only 10 counties out of 58 accepted Prop 90 transfers when that was in effect, because they were losing so much revenue. And that's why a universal Prop 90 would cost the state in terms of revenue so much money.
Thank you for your response. A lot of people, did not understand Proposition 19 when it was on the ballot. And now they're seeing that there are a lot of hidden issues that they may not like. And there may be people who want to see it reversed. And so is there any chance that they can abolish Proposition 19 by voting on it? Really, what is left for them to do for folks who are not happy with this?
Well, very good question. A lot of us aren't happy with it. It's the way it's worded. The purpose is well understood, the intent, but the implementation is very, very difficult because of the uncertainty about no implementing language. The answer is it's embedded in the state constitution. The only way you change something in the state constitution other than going to court and have it declared unconstitutional is a vote of the people. And so it's not as easy as it sounds. You get a ballot measure on either because the legislature puts it on there, or you go the initiative route where you gather enough signatures to put it onto the ballot. And it takes time. So these are the kind of things that once you put something in the state constitution, it is very, very difficult to change it because you'd have to go through another election. And this wasn't that, this was a close election to begin with, and you have no guarantee that in fact people would vote for it. Some people are very upset by Proposition 19, mainly the parent to child transfers, because it limits the benefits that they get severely. On the other hand, people on the other part of the initiative are in favor of it because it allows them to transfer their lowest assessed value to any home in California, all 58 counties. So if you put that on the ballot, you'd have some people wanting to change it and the other people not. So there's no guarantee that it would pass.
As I listened to this presentation and I heard all of this information, it occurred to me how difficult, it is to maybe understand this. Do you find that people, need to seek either legal representation or outside support to understand this process and navigate it, or do people actually do this on their own? And do you have tools to help them do that? I just wonder, because as I listened, I thought, how does this apply to me? And in our chat box, we have a lot of people who have very individual, personalized questions that I know we won't be able to get to this evening.
In some cases, particularly on the parent to child side, can be very complex, and it could be different for different circumstances. I would not try to do this if you had a complicated case without some kind of legal or professional advice. On the other side of the transaction, the Prop 6090 side of Proposition 19, it's fairly straightforward, but there are complexities. There's a lot of questions that came in on the chat, which are individual oriented. And so there's a lot of things that people can do and they can't do. And we will provide, my office is very accessible, and we will provide all the information we can without providing legal advice.
We're going to ask a few questions that hopefully address a number of scenarios that will apply to a number of people. And that might be one helpful way to share more information this evening. So I'll start with this one. If I sell my home to my kids, can I pass on the low assessed value to them while also transferring my low assessed value to another home?
Well, unfortunately, the answer is no. You can either keep your low base, so you can take it with you, or you can actually transfer to your child. So you cannot do both. It's only one. Yeah.
Thank you. Thank you for clarifying that question. Here's another scenario, could apply to lots of people. We are an unmarried couple and interested in selling 2 homes that we each now own separately and moving to one larger, more expensive home together. Can we both take advantage of Prop 19 tax breaks?
Debbie, would you be able to answer that question?
You're muted, David.
Sorry about that. Can you repeat the question? I apologize. I was responding to some of the Q&A in the chat.
Thank
Sorry
you.
about
We
that.
appreciate
Go ahead.
in responding to those questions. Here's the question. We are an unmarried couple and interested in selling 2 homes that we each now own separately and moving to one larger, more expensive home together.
Right.
Can we both take advantage of Proposition 19 tax breaks?
Yeah, so the answer is, if the goal is to take your low assessed value from each home and move it to one single home, the answer is no. You can only move one to the other home. You can only transfer it, one of the assessed values.
Thank you. Thank you for clarifying. Here's another situation. And again, we chose these particular scenarios because I think they could apply to a number of people. I am single with no children, and as many other professionals here in Silicon Valley, I'm interested in learning about transferring my assessed value to my siblings and one nephew. Can I do that?
The answer is no. Transfers between siblings, nephew, family members cannot be excluded from reassessment, meaning if anybody wants to transfer the property to their siblings or a nephew, the property will be reassessed fair market value. So there's no base year that can be transferred to any of them.
Thank you. This question relates to elder clients. How can we counsel an elderly who sold in 2020 and bought down, but now want to move again, stay in California and in the same county?
So in this situation, once you have transferred your assessed value, you did it in this example to Prop 6, so you bought down. That's your new assessed value. You can't then, if you transfer again, you are transferring based upon the sale price of your smaller home, as it were. If you downsize, you bought a smaller home, and then now you decide to move to another county and buy a bigger home, you can't reach back to the lowest sale price that you could use as a comparison or something. You have to use the most recent.
Thank you. Very helpful. Interesting question. Will buyers or sellers still be responsible for additional city or county taxes, such as construction and conveyance taxes?
This on this here, in terms of taxes, the taxes are going to be the same as any other when there's a transfer. So if there's a transfer tax, those still apply like any other situation. I think it's important for people to know that what you're transferring is your assessed value. So if I move to I move to a new home and it's in a different school district, the taxes, your property taxes, while your assessed value may be the same, your taxes may go up or down depending upon the various bonds and various tax measures in that jurisdiction. Because that ultimately you're paying, if your assessed value is $500,000 and and there's a bond measure, and there's a parcel tax, those are going to vary from jurisdiction to jurisdiction. And so your taxes, your actual amount you're paying could go up, it could go down, but your assessed value is what we're focused on. Thanks.
Thank you. Here's another question that we have. Can you move your tax base from your primary residence to an already owned rental property when selling the primary residence?
No, you cannot. You have to move to a new property.
Wonderful. Thank you for clarifying. Someone asked, I'm interested in building a lot I bought a decade ago. If I sell my house and build on the lot, can I transfer my assessed value to my newly constructed home?
Debbie, do you want to answer that?
Larry?
Debbie, I said, if you're available.
Yeah, can you hear me? Is my voice
I
okay?
can hear you. Yes, Debbie. Thank you for joining us.
Sure. Yes, you can transfer it over to a newly constructed home as long as the construction is complete within 2 years of selling the original property. The only thing is that, well, with Prop 19, the value restriction still goes away, but if they sell for $1 million and market value of the new construction along with the land is greater than that, they will be charged for the difference in their assessment.
A number of people tonight are asking how the presentations that were shared tonight can be made available to them. Where can they find them? Are there ways that they can continue learning about this proposition? How can they go about it? Do we have other seminars planned in the near future if people want to continue diving deeper into these topics?
Well, we have, as I said, we've I think done 3 of these. This is the 4th one. Combined with what's on the line today, we've made these presentations differently because we've focused on a broader, both parts of Proposition 19 are focused on before primarily the parent to child transfers to well over 3,000 people in the last 2 weeks, I think. And we have 3 more scheduled, I believe, next week. So by the time we're through with this, I mean, what this tells me is there's so much interest. You know, I've been the assessor for 26 years, and I don't think I've ever spoken to, 4,000 or 5,000 people in a month's time on any issue. So it's very controversial, and it's very confusing. I think the confusion trumps the how controversial it is. And that's why so many people are interested in it, because it affects so many people. So the answer is yes, we're doing other seminars. Mainly, we did one to the Bar Association and the lawyers involved in property issues. We had 1,700 people on that. We did one the next day with 650 for a title company, primarily title people and a few realtors. And then another one the next day, a couple of days later, I guess, for 450 people, which were title company and property interest folks. I don't know what the composition of the other 2 or 3 that we have next week, but it's fairly significant. And can you get the text? You can. We can give you a text of my presentation because it was prepared. I don't know about the rest of it, but I just say if you're really interested or have things that were confusing because we were confusing, then you dial into one of these other webinars that we'll be doing. I don't know, David, do you have any thing to add to that? You're
muted.
Yes,
David.
thank you. The only other question that somebody had asked, they sent in their Prop 58 forms, this was from Nora, back on February 7th, but they still haven't heard back from the assessor's office. When can I expect to know if they've been approved? And Nora can speak to this more specifically, but we've received more Prop 58 applications in December and January than we did the entire prior year, pretty much. I mean, the stack runs higher than some of our employees. So it's a large volume. We're in the process of opening that mail. Nora, can you answer the specific question of when roughly can, if I sent something in, I'd be like, gee, did they even get it? How do I know they got it? Et cetera, et cetera. Nora?
Yes, absolutely. And by the way, David is not kidding about the mail. Okay, it's huge piles of mail. I took pictures of it. Yes, so right now we are definitely closing the roll. Those are the 2020 transfers. My staff is already processing 2021 transfers January. So we're going to be jumping into February transfers pretty soon. So if somebody already submitted the Proposition 58 claim form, once we process the transfer, the change in ownership transfer, we will definitely be notifying the taxpayer whether the claim form that was filed is missing certain information, or if it was accepted and the exclusion was filed, we're going to send a letter back to the taxpayer letting them know that the exclusion has been approved.
Thank you. One of the things that I wanted to ask before we come to a close, and our time is almost up, is I know, Ms. Galvez, you mentioned that there's a process right now where rules and forms are being created around this intergeneration portion of Proposition 19. What can we expect to come from that process that is currently happening right now?
Are you talking about the what we're currently seeing as people apply for Proposition 19, or because what we're currently seeing is perhaps a lot of people will not be able to qualify for fully excluded, under Proposition 58, 193. We are anticipating to see less of these type of transfers that people might qualify under Proposition 19.
Thank you. Well, before we come to a close, I wanted to provide you with the opportunity to share anything else before we close. I know everyone's been following the chat and looking to see if any other issues have risen to the surface. So I kind of want to open the floor and see if there's anything you'd like to add before we begin to close.
Actually, I do want to add to what Mr. Stone stated earlier. We do have great information in our website. Our IS department has been amazing in providing this information and putting in our website. Something that I did forgot to mention to all of you is that, that value test that I presented in my presentation, you can go to our website and we actually have that in our website. All you need to get is the fair market value of the home and the current assessed value. So you get that information, you can go to our website and you can definitely get the new base year value that perhaps might be applied to your property. So there's great resources that we have in our website.
And yes, in behalf of my staff, David, Nora, Lori, my secretary, and all of the staff, thank you very much. This was a real service that you have been doing, and I hope you continue to do it. And as you can see, there was substantial interest in this issue throughout the county. So thank you very much for allowing us to make this presentation to your audience.
We thank you for your time. This has been tremendously informative. I've learned a lot myself personally, and I have way more questions in the back of my mind as I listened to this presentation. I want to thank all of you, our presenters this evening, for being with us and just being very generous with your time. I'd also like to thank everyone who has tuned in from our San Jose Spotlight community, all of our readers, followers, and supporters. A video recording of today's presentation and the Q&A will be available on our website next week. And if you want to continue following our coverage and learning about how to support San Jose Spotlight, we want to invite you to visit our website, sanjosespotlight.com. Once again, we want to thank everyone for joining us this afternoon. It has been a pleasure, very informative talk, and we look forward to having future discussions on topics like these. Once again, thank you. This event is now has come to a close, and we hope everyone has a wonderful and safe evening. Thank you once again on behalf of San Jose Spotlight.
Let's go.
Thank you.
Thank you.